Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. On January 15, 2024, the European Commission issued a report to the European Parliament and Council that Canada's privacy law is adequate from a European point of view. Canada was among a number of countries reviewed in this particular report. At least for Canada, this review has been long awaited and long anticipated. Some people have been saying that Canada has been lagging behind when it comes to privacy protection and needs substantial reform to keep up with the European gold standard. Well, that's been proven to be untrue. The concept of adequacy under European data protection law, particularly under the General Data Protection Regulation, or GDPR, refers to a mechanism by which the European Union, or EU, determines whether a non-EU country offers an adequate level of data protection that is essentially equivalent to that provided within the EU. This originally came from Article 25 of the now superseded European Data Protection Directive. In a nutshell, you can't transfer European personal data outside of the European Union unless you can ensure an adequate level of protection for that personal data. If you were around in the late 1990s, you'll recall that European adequacy was a big driver for Canada to implement a general privacy law to facilitate trade between Canada and Europe. The European Commission, the executive arm of the EU, has the authority to assess the level of data protection in a third country. If the Commission finds that the country ensures an adequate level of protection, it will issue an adequacy decision. This decision implies that the personal data can flow from the EU to that third country without any further safeguards being necessary. The adequacy assessment covers several factors such as rule of law, respect for human rights and fundamental freedoms, relevant legislation, both general and sectoral, data protection rules, enforcement mechanisms, international commitments to the third country that might have been entered into regarding data protection. Once a country is deemed adequate, data transfers to that country are treated almost like intra-EU transfers, simplifying the process for companies and entities that handle personal data across borders. It eliminates the need for additional data protection measures like standard contractual clauses or binding corporate rules that are otherwise required for data transfers to countries without an adequacy finding. Adequacy decisions are not permanent and are subject to periodic reviews to ensure that the adequate level of data protection is maintained. The EU can suspend, amend, or repeal an adequacy decision if the third country no longer provides an adequate level of data protection. The GDPR, in fact, requires that the Commission review adequacy findings every 4 years. Since this particular report was issued earlier this month, at least in Canada, we can say that it's business as usual. And that's true. But I think this decision or determination is interesting in a number of ways that I'd like to highlight. Now, for a long time, and particularly since the European Union's General Data Protection Regulation came into effect, privacy advocates here have been saying that Canada has been lagging behind when it comes to privacy laws, and that we'd have to essentially adopt a Canadian version of the GDPR in order to maintain our adequacy. We presently have a replacement privacy law pending in Parliament in the form of Bill C-27, named the Consumer Privacy Protection Act. Now, it's interesting, at least to me, that the Commission's report is based on the current state of affairs under PIPA. The staff report mentions Bill C-27 and the Consumer Privacy Protection Act, but only in one paragraph. So the Commission concludes that in 2024, that PIPA is sufficient and adequate for European purposes. One thing that really stuck out to me is that the Commission's report relies on what I think is a huge myth about PIPA. The staff working document, which accompanied the report, says, quote, "Any processing that takes place across provincial or international borders, or that is carried out by federally regulated businesses, regardless of where it takes place, remains subject to PIPA." And, quote, "Data transfers from the EU EEA under the adequacy decision are considered cross-border data transfers, which are subject to PIPA," unquote. Now, some people think that this is actually the case, but PIPA doesn't say that. The word border doesn't appear in PIPA, nor does it refer to international or interprovincial transfers. The entire scope of PIPA is set out in Section 4, and it simply does not say what the European Commission says it does. Now, I note that the Commission's report is full of footnotes, but there's no footnote to that assertion. When the CPPA comes into effect, it tries to remedy that by including a subsection that says, quote, "For greater certainty, This act applies in respect of personal information that is collected, used, or disclosed interprovincially or internationally by an organization. I'm not sure that entirely fixes it, but that's a topic for another discussion. What's also interesting is that many privacy advocates have been saying that the commissioner under PIPA or its replacement must have order-making powers and the ability to levy hefty penalties in order to maintain our adequacy. Privacy regulators in Europe now can impose huge fines, and of course ours must be able to as well to maintain adequacy, you'd think. Well, that's not how it played out. The European Commission found that the present system under PIPA, in which the commissioner has strong powers to investigate, but virtually no remedial powers, they found it to be sufficient. The Commission noted that individuals can go to court after the OPC's investigation, and the court process can result in binding orders and compensation for damages. The Europeans were particularly impressed with the OPC taking Facebook to court in 2020, quote, and this is what they said, to seek a binding enforcement order to ensure that Facebook's unlawful privacy practices are corrected, unquote. The footnote refers to the litigation being ongoing, but didn't note the OPC's huge loss in the federal court, which is being appealed. I did a video on that federal court decision, which I'll link to below, and I'd note that the appeal is scheduled to be heard on February 21. So the Europeans were satisfied with their statutory privacy protections, but the discussion doesn't end there. The staff report does a really deep dive into just about all the ways that government, including law enforcement and national security agencies, are able to get access to personal information, including personal information transferred from the EU. The report talks about the charter, the legal frameworks and judicial authorizations required for warrants, wiretapping, and the like. It discusses what sort of redress is available to aggrieved individuals. Though I can personally be quite cranky about governments, I think the European Commission's conclusion makes sense. The Commission concludes that public authorities in Canada are subject to clear, precise, and accessible rules under which such authorities can access and subsequently use for public interest objectives, in particular criminal, law enforcement, and national security purposes, data transferred from the EU. These limitations and safeguards, they say, follow from the overarching constitutional framework, being our Charter of Rights and Freedoms, followed by case law, specific legislation regulating access to data, as well as the federal and provincial public sector privacy laws. They conclude that the Canadian legal system provides effective oversight and redress mechanisms in this area, and note particularly that the right to access one's own information has been extended to non-Canadian nationals or residents. So they conclude, based on the overall findings set out in the staff working document, that Canada continues to provide an adequate level of protection for personal data transferred from the EU to recipients who are subject to PIPA. And I think that's the right result. I expect we will hear from people who think that we're really not that adequate, that the decision was maybe made on political grounds. Now, I can't really refute that, but if they were going to get looking at where politics could come into play, the Commission could have focused on the Consumer Privacy Protection Act to give advocates and the current government more support for their arguments. But in any event, one thing that we can confidently conclude is that if Canada's privacy regime is adequate for European purposes right now, it will definitely be so in 4 years if the Consumer Privacy Protection Act comes into force. I hope this has been interesting and useful. I try to put out a new video every few weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian technology and privacy law. Thanks for tuning in.